today we're sharing information, but then the panelists that are here are we're going to address real life stories, and I have to do a disclaimer. When I say real life stories, they are quote unquote fictional real life stories. None of the names or the situations are real families, but we're going to use case studies, and the situations certainly could be real life. So our first case study is going to be Mr. and Mrs. Weber. But before we get to the Webers, what I'd like to do is set the stage a bit for us in terms of the information that is really impacting America. Debbie, can you tell us a little bit about what it means to be aging in America?
I sure can. Now you can see on the slide that we're growing in numbers. And the number of Americans age 65 and older is going to double in the next 20 years. So we're looking at 80 million individuals by 2040. And when you think about the group that's going to need the most care, those are the ones that are 85 years and older. So planning ahead for a quality of life when you're focusing on your health care isn't just that. We need to look at the quality of our health as well as our financial security. These statistics can be a bit startling. We have lottery numbers that are this big, and we have winners in that. When we look at the total payments of care dollars for Americans aged 65 and older with Alzheimer's and other dementias, it's estimated to be $321 billion, add a B onto that. Now, this doesn't include any informal care that people provide. The out-of-pocket expenses. Medicare and Medicaid are expected to cover about 64% of those costs. That leaves the rest, out-of-pocket expenses, the burden of the individual. So out-of-pocket expenses are expected to be $81 billion. And that's a devastating amount considering we're also dealing with a devastating disease.
So as we're talking about aging and transition, the natural question that comes next is, well, what do we do? How do we plan for this? And that's where an estate plan is so instrumental. And an estate plan is primarily for probate avoidance. Now, probate avoidance is so important, right? But that's only one aspect of an estate plan. As you can see, there are 4 common estate planning documents that, commonly are referred to as an estate plan, and that's the durable power of attorney, the patient advocate, a revocable trust, and a last will and testament. And this is your emergency action plan. And in each one of these documents, you are nominating a fiduciary. Now, a fiduciary is a decision-making surrogate. So if you are unable to make a decision for yourself, then somebody is able to step in and make that decision for you. Now, there are many different types of fiduciaries. Those fiduciaries that require probate court authority and supervision, such as a conservator, a guardian, a personal representative. And then there's the other fiduciaries that you do not need probate court oversight, and that's the power of attorney, the patient advocate, and the trustee. So when we're talking about these 4 documents together, it's to ensure that you have not just probate avoidance, but making sure that when something happens to you, right, here and now, during your incapacity or as things start to slow down, that you have somebody to jump in and to assist without the need and the oversight and the stress and the cost of going through probate court. So a durable power of attorney. Now, we have a younger colleague in our office, and I just adore her, and she says, oh my God, Kristen, the durable power of attorney is the everyday document, is the functional document that you need in order just to do day-to-day things like pay bills, file your taxes, call AT&T and try to get a human on the phone, which is almost impossible. And this document is wonderful, right? Because it allows for flexibility, a surrogate decision-making, not only during your lifetime, but during your incapacity. But this document goes away when you pass away. The patient advocate, this is another phenomenal tool, is when you are unable to make a medical decision, somebody steps in and has a framework and a guidebook as to what decisions you would like to make, right? Not that the person would like to make, but what you would like to make. And, making medical treatment, to start treatment, to stop treatment, to even potentially end-of-life decisions. And again, this document goes away when you pass away. Now, the revocable trust. I love the revocable trust because I think it's so much more than, a bunch of legal jargon and tax information. It's your story, right? How many times do we get to actually put down our family story in one spot? And that's a revocable trust. And the most amazing thing is that you're able to use it during your lifetime, during your incapacity, and after you pass away. I mean, it's just a beautiful transitionary tool that tells your and your family story. And then last but not least is the last will and testament. And this is that document that you need in case you need to go to probate. And, if you don't have that last will and testament, well, I'm going to tell you what, the state of Michigan is going to direct and tell, your family as to how those assets need to be distributed. So overall, this estate plan is to ensure, again, probate avoidance, absolutely. But more importantly, like I said in the beginning, we're flipping estate planning on its head and really focusing on what happens when we are here now and we need somebody to jump in and take care of us.
I can't help myself. Before I introduce the Webbers, I have to tell a story. When I was a new lawyer, and I can tell the story, and I could even use the names because the file's up at the probate courthouse. A husband and wife were aging. They were in a nursing home. The wife was losing capacity for sure. The husband thought he was the best person to be named as the guardian and conservator for his wife because they had done no estate planning. They were not clients of my firm. They came to us separate from, we didn't do estate planning for them. The son, the only son, thought he was the best person to take care of his mother who was starting to, lose her ability to function. And so what happened? The father and the son litigated over who the best person to serve for the mother would be, or the wife. And actually the father lost that litigation and the son was appointed. And the father was so angry with his son, he did then do estate planning. He disinherited his son to the tune of $4 million, which when I started practicing law was a lot of money. It's still a lot of money, but it was a lot of money 30 years ago. And then he died. And the son contested the will that he had been disinherited from, or the trust that he had been disinherited from. And the sole beneficiary was the State of Michigan General Fund. This is how mad the father was. State of Michigan General Fund, who leaves their money to the State of Michigan? He said he thought that the State of Michigan would hire very good lawyers to defend his document. So 10 years of litigation later, the case settled. The moral of the story, while you are alive and well, tell us what you want to have happen, right? We all have the ability to say what we want to have happen, who should be in charge, who gets what when, and beyond that, how we want to be taken care of. And it's that beyond that which is really so interesting to me and is not really so much the legal part as is thinking about how all the legal documents really play out. Anyway, I had to tell that story. I always tell the $4 million disinheritance left my money to the State of Michigan story, so I had to get it in somewhere. I'm sorry. We'll go to the Webbers now. This is back on script. So Mr. and Mrs. Webber are what I'm going to call Mr. and Mrs. Independent. They're in their 70s, they're retired, and they want to make all of their own decisions. Who has parents in this category? All of their own decisions. They've got it together. They don't need anybody's help. They don't want to burden their daughter. Their daughter has, you'll see in the picture, their daughter has her own family and her own issues, so they don't want to burden her. They do love their grandchildren immensely. They'd love to do something special for their grandchildren. They don't have any estate planning documents. But most importantly, the thing that's now prompted them to do a little thinking is somebody had a health scare. And I find this in my practice to be perfectly true. Somebody has an event, and all of a sudden it's like, oh my gosh, the light bulb goes on. I better do something. That's not when we should be thinking about these things, but we'll get to that. So Mr. and Mrs. Weber, this is what they come to with. I'd like to have our panelists give us some input on what the Webers should be doing, what should they be thinking about, what's the action plan for Mr. and Mrs. Weber?
So this is the emergency action plan that we've been talking about, the what ifs. And the Webers have, had a trigger that had them pause and say, we need to start taking this seriously. And, sometimes we joke, and this kills me to say it, that, estate planning is the only area where you can be a C student. So just listen to me, hear me out, is that you can get up to 70% there, but then the rest, the 30% is the unknown. Right? We cannot anticipate what is potentially going to happen 2 years, 5 years, 10 years from now. So if we get 70% there, then we have our action plan in place and we have an ability to adjust, to move, to transition. So talking with the Webers is talking through what is your emergency action plan if something were to happen to you now, today. Do you have the right person in place? And we talk a lot about who is that right person, right? The person that has the ability, the capability, the capacity to act as a surrogate decision maker. And also the peace of mind that, when we talk through the gift, is being able to provide two things. One, the gift upon our passing, but two, the gift of resources to the person that we are putting in place to implement that emergency action plan. So the estate planning for the Webers is, let's get a plan in place. Let's be a C student for now. Let's adjust as life adjusts with us, because this is a living, breathing document, just like our families, right? We move, we adjust when the time is necessary. But part of that emergency action plan is what my patient advocate should know. And the family doesn't want to burden their daughter who's got a family, young children, has an active life. And if there is an emergency that pops up, they want to give her a tool set to be able to walk forward. With that tool set, Jamie, how do you suggest and how would you recommend the implementation of a care manager?
So first of all, along with their estate planning documents is preparing their patient advocate. There are a lot of patient advocates floating around out in the world right now that don't know that they're named as somebody's patient advocate. So what do you need to tell your patient advocate as much as possible? They should know your medications that you're taking, the allergies, the medication allergies that you have. They should know your past surgical history. They need to know whether or not you have metal in your body, because these are the questions that the hospital will present to them as they are trying to treat you if you are incapacitated or unconscious when you get to the hospital. Now, a lot of people think, okay, but I have all that information in my Beaumont chart, which I guess Beaumont's going to change names. But so, the hospital will have all that information and they already know it. But what happens if you're out of town and you're visiting your grandchildren and you have a medical emergency? What happens if you have a medical emergency at the grocery store and Henry Ford is the closest hospital and that's not the hospital that has your records? So preparing that patient advocate ahead of time is very important, just communicating with them. In our situation here, Joe and Fran, they actually opted to bring in a care manager to help prepare their patient advocate. So as a care manager coming in, with my nursing background, I'm looking very medically specific, right? I want to try to get all the information that the hospital might need. So I'm going to prepare you an emergency document, or an emergency folder in case you end up going to the emergency room. And then we're going to compile all the medical records, all the doctors, all the different providers you see, and we need to make sure that your patient advocate has that information. Because if they have to step in and take over for you, we've literally presented it in a gift to them where all the information is in one spot. So part of what I'm doing as a care manager is helping prepare your patient advocate. Advanced directives are also a big discussion piece with your patient advocate. Advanced directives are the medical procedures that you may want and don't want. Okay, so maybe more importantly, we need to talk about don't want. And advanced directives and your code status in the hospital, these things are fluid, meaning they're going to change with every change in your health, with every hospitalization. So having this discussion one time with your estate planning attorneys and then putting that in a book and putting it away doesn't help your patient advocate. It's something you need to continually address. For example, there was a health scare with Fran. So, if we have a new terminal diagnosis, we really want to visit those end-of-life decisions and revisit all those advanced directives and medical choice options. There's actually a handout on the Schluter and Hughes table over there as well, really kind of detailing through some of those advanced directives. So again, having a care manager help prepare and go through a family with this sometimes can be unnerving, but then now that patient advocate, as well as that family, has a team of care managers on call for them. So something happens and there's a new crisis for Fran, they have someone to call.
Okay. So I'm just going to recap because I think this is fascinating. So Mr. and Mrs. Weber, super independent. They don't want to burden their daughter. What should they be doing? They should be doing a good estate plan. They should be thinking through these issues. The plan needs to be prepared. It needs to be signed. It can't be unsigned and sitting in a file someplace waiting for a day that, another scare. It needs to be done. It doesn't have to be perfect. It can be changed later. This is the 70% rule. They don't want to burden their daughter. I can see that. I don't really need to know everything about my parents' medical situations. I don't really want to know all that right now. They really don't want to tell me. I put an intermediary in to help prepare what the patient advocate would need to have in order to jump into action and be prepared. Is that the daughter doesn't need to act as the trustee or the fiduciary, but reaching out to a third party, a professional who does provide trust services and financial oversight can be a solution so that you're not burdening a child or a family member who already has a full plate. So this is what I heard from our panelists for the Webers. They've got a cohesive, what I would call multifaceted approach to put their arms around the clients and make them comfortable. I love it.